first thing I want to say, though, is that I don't use the term criminal and family justice systems. In the work that I do with women who've left abusive relationships and their children, I can tell you what most of you already know, and that is that there is little or no justice for those women to be found in those systems. So I don't use that word because I think it is dishonoring and disrespectful to the experiences that unfortunately women continue to have when they engage with either or both of the criminal and family court systems. Before I can talk to you about strategies, though, I need to just take a couple of minutes to identify where the gaps are and where the challenges are. First and foremost, most women do not understand the fact that they are entering two distinct systems if they're involved with both criminal and family court. Further to that, they may be very unwilling participants in the criminal process. They may not have been the person who called the police to the door. Even if they did, they may not have understood that because of mandatory charging directives in this country, they're losing a lot of autonomy the minute that call is made, the minute that officer arrives at the door. They may not want their partner charged. They may have been charged themselves. As a result, they may be resistant or even hostile to the process. And we've heard earlier today about the challenges for women who present as hostile. The systems, the legal systems, family and criminal, continue to like victims who are passive, who are weak, who expose their vulnerability. Those systems do not like angry women. They do not like hostile women. They do not like women who stand up for themselves, because that defies our societal understanding of what it means to be a victim. It makes it harder for those systems to believe that those women were harmed by their partners. When women are resistant or hostile, it affects their ability to give effective testimony. That affects the sympathy of the court, and in criminal court, that affects outcomes like bail. Bail then affects ongoing or new arrangements for the children, and now we see the two systems acting together in a complicit way that's not helpful to the safety of women or their children. Women, like all what I think of as normal people, which is people who don't work and live and breathe in the courts, see their experience holistically. They're going to court. They have to give evidence. They see the courtroom, not a family courtroom here and a criminal courtroom there. They see the judge, a person, often white, often male, in a black robe with a sash. That's one person to them. There's no distinction between the person who's looking like that in the criminal court and the person who's looking like that in family court. That makes it hard for them to understand why they need to tell their story again and again and again. They assume, and who wouldn't, that the information they've given in one process is shared with the other process. They assume, and again, who wouldn't, that the approach taken by both systems is similar, that the goals are the same, and so on. But what's the reality? The reality is that criminal court is about the guilt or acquittal of the accused. It's not about the woman or her children. Family court, on the other hand, wants the family to move forward post-separation and is only minimally concerned with the wrongdoing of either party. The standards of proof are different. Unless the woman has been charged, she's not a party in criminal court, which means she can't apply for legal aid, she doesn't have a lawyer, and the Crown Attorney, let's all remember, is not her lawyer. The outcomes in the two courts can conflict, and the two systems do not communicate. The impact of all of this on a woman who's navigating both systems is immense. She's confused about what information has been provided to which court, what role she's supposed to play, the roles of others that she encounters in those systems, and she's frustrated, and she and her children are left unsafe as the result of orders from two courts that conflict with one another. Her abuser may use the criminal proceedings to slow down the family court proceedings, leaving her and her children in a situation where they don't have any orders to assist them. He may also try to bargain, and I put quotation marks around that word because it's really bargaining in very bad faith. He may try to bargain with her between the two. In other words, if you talk to the Crown and try to get this charge dropped, I won't fight you for custody. Or if you conveniently forget when you're in the witness box in criminal court and you don't have much to say by way of evidence against me, I won't fight you for custody. Well, it's bargaining in bad faith because even if she does that, he still fights her for custody. Risk factors for children, people have talked about this morning, so I just want to very quickly reiterate that at this time when their mother may be engaged in both court systems, the risk factors for kids are enormous. They have, of course, ongoing exposure to what is now possibly increased violence against their mother. They're experiencing new forms of violence, including child homicide. And for many of those children, they're spending time alone with their father for the first time in their lives. So what can we do about it? I'm going to look at the criminal system first. And we do have some things here that are working that we need to build on. We have a lot more things we have to begin to address that we haven't yet started. Bail safety programs. Some of you may be in communities that have these programs. Unfortunately, they're not yet available in all court jurisdictions. Where they are available, they've proven very helpful in cases of woman abuse. The primary focus in a bail safety program is to gather information at the bail stage that can contribute to the safety of the woman through to an appropriate outcome at the bail hearing, which for many women is the highest risk point. We need domestic violence, and I'm using that term on purpose. We need domestic violence training for justices of the peace. These are the people who 9 times out of 10 are sitting in bail court. My recommendation is that that training be similar to the training that's been developed by the National Judicial Institute for judges. JPs have got to understand the unique dynamics in violence against women cases, and they need to take them into account when they're making bail-related decisions. Use of not-for-profit bail programs, and I know there's one in Toronto, there may be similar programs elsewhere, need to be more carefully regulated to ensure that those people have domestic violence training and that they understand the unique issues to be considered in those cases. I'm using the term domestic violence here because that's the language of these systems. That's not my language. My language is violence against women. It should be a requirement that justices of the peace have, as part of the evidence in a bail hearing, any outstanding family court documents or orders related to custody, access, or restraining orders. This shouldn't be luck of the draw, that this particular JP asks for that documentation and this other one does not. Right now, Ontario's Justice on Target initiative is conducting a review of bail in Ontario, all bail, not just bail in domestic violence cases. This has led to the establishment of a bail experts table, and that table has identified that there are unique bail issues in domestic violence cases. All of us can be having input to that process and saying, okay, now that you've identified that fact, what are you going to do about it? Which goes back to what Linda said this morning. We know it, but do we get it? Okay, we know they're unique. Great. What are we going to do about bail to acknowledge the fact that these are unique situations? And I want to also say that privacy rights of the accused notwithstanding, and I understand absolutely the importance of those rights, we must find a way that information can be shared in a fulsome and timely manner between criminal and family court. It is simply too easy for an abuser to manipulate both systems to his advantage, and this can be made easier when no information is shared between the two. Finally, with respect to criminal court, when a breach of a family court restraining order is brought into the criminal system, and that should be starting to happen now, because due to recent changes to the Family Law Act, breaches of restraining orders are now criminal offenses. That breach needs to be treated as seriously as any other criminal charge, and not dismissed or treated lightly because it's seen as a family court issue. So what could we do in family court? First of all, and some of these, I know I'm supposed to be talking about gaps between the two systems, and I'm doing that, but there's some really big problems in family court that are just about family court, and you're all sitting there and I've got the mic, so I'm going to tell you about a few of those too. There has to be a proper understanding of the reality of ongoing violence after the couple separates. The court needs to understand the impact this has on children's emotional and physical safety, as well as on the safety of women, and on the ability of women to engage effectively with the court system. Any kind of risk or threat assessment has to understand the dynamic nature of risk in these cases. I think there's often a tendency to assume that risk is on a steady decline, at least once the court proceeding is over, and nothing could be farther from the truth. Risk in these cases, when there are children in particular, escalates and drops for years. An escalation can be triggered by mom having a new partner. Could be 5 years after a custody order is in place. 5 years where things have been going relatively smoothly. Something triggers a response from the abuser, and mom and the children are back at risk again. So this needs to be looked at in terms of things like the ease of bringing a case back to court if such a moment arises, but also how do we manage supervised access, for instance, as an outcome, without assuming that supervised access always leads to unsupervised access. The new restraining order provisions must be used more aggressively than they are presently being used by judges in family court, because that can move a case into the criminal system. Legal bullying has to be managed. What does that mean? We need case management in family court, and we need more effective, more aggressive use of both the family law rules and the Courts of Justice Act so that legal bullying is shut down. We need less emphasis on alternative dispute resolution. Women continue to feel pressured into mediation with abusive partners that result in outcomes that leave everybody, by everyone I mean the woman and her children, exposed to ongoing risk. The best interest of the child test now and for 7 years has contained a requirement that the court consider family violence. I would like to suggest that we still need to make sure that lawyers and judges understand that that provision is in there, because we continue to work with women who tell us their lawyers say, I'm not going to put that family violence in your affidavit because the judge doesn't want to hear about it. Well, you know what? I don't really care whether the judge wants to hear about it. The law says the judge has to consider it. And women are vulnerable enough at this point, they shouldn't have to be arguing with their own lawyers about what kind of evidence to present. So we need to do some pretty serious education there. And speaking of that, we need training and more training for those people who are doing family court assessments, for the agents who work for the Office of the Children's Lawyer, mediators, supervised access supervisors, parenting coordinators, lawyers, and judges. We need to understand in family court that the standard of proof is on a balance of probabilities, not beyond a reasonable doubt. And among other things, that means that when he's acquitted in criminal court, that doesn't allow the judge in family court to doubt the woman's story that she's been experiencing abuse. Custody and access decisions must start from the understanding that children are safe and only safe when their mothers are safe, both emotionally and physically. All family court orders must include a police enforcement clause, and we need to work with our local police agencies to help them understand that they must enforce those orders. I have a lot more I'd like to say. I'm going to end with 2 very brief, overarching comments and hope that after this event today, we can find ways to have further discussions that let us explore some of these topics in greater detail. 2 things. First of all, I understand that this event is focused on minimizing risk to children. But I need to say that we also need to pay attention to women without children. Too often, all of our responses criminal, and in particular family, are focused on keeping moms safe so their kids are safe, that matters. But women without children matter too. And secondly, with respect to family court, we'd be looking at a situation where more women were kept safe, where more women came close to experiencing justice, if we made sure that every woman in this province had a lawyer when she went to family court. Thank you.